Hello, my name is Albert Gibbon and welcome to this Pump Court Chambers webinar. I am a junior at Pump Court Chambers. On the civil side of my practice, I have quite a mixed practice ranging from contractual disputes to late payments of commercial debts to RTAs and personal injury claims. I'm here to talk today, as you can see from the slide, about requests for further information. And this is part of season 2 of the new practitioner series at Pump Court Chambers. What this presentation is aimed at is at people who might be a little less familiar with the content of Part 18, who are either coming to it afresh, looking for a broad overview of the area of the civil procedure rules in this area of law. What I am going to do is I will keep it light and swift. Of course, it goes without saying that there's no substitute for reading the relevant rules, practice directions, and judgments. But my hope is that after this presentation, you effectively have a bit better of an understanding of this area of the rules. If you're short on time, you'll see within the slide deck that I have included a few precedents which can be followed, whether you're making a request, responding, or making an application, and hopefully those are of help too. So looking at today, first I'll give you a brief introduction and overview of CPR Part 18. We'll look at if you are the party making a request, if you're the party responding to a request, if you need to effectively make an application or respond to one and enter the court arena, before we finish up by looking at some of the practical considerations when dealing with a request of this nature. So question number one, what is a request for further information? Well, it's a request from one party to another outside of court for information to either clarify a statement or give additional information in relation to an issue or matters which are in dispute, which I'll come on to. As I've said, whilst it doesn't immediately involve applications and hearings, it of course can end up there, and indeed the court can make orders of their own volition under CPR 18.1. And when the court does so, there are provisions set out in 18.1 as to how and when you ought to respond to a request that's been made or ordered, as it were. Again, under 18.2, the court can direct that information provided by a party to another party, whether given voluntarily or following an order being made, must not be used for any purpose except for that of the proceedings in which it's given. So that's effectively just to ensure that parties aren't making requests in order to gain some sort of secondary benefit in some other set of proceedings or for some other purpose. What is a matter in dispute? Well, you've heard me already say that a request for further information has to relate to an issue or a matter in dispute. As you can imagine, the question arises, well, what's a matter in dispute? And it's been given some considerable judicial consideration. The case that's just come up on the screen there is the case of Pacific Biosciences. And in that case, Mr. Justice Norris considered that a request for further information arose as part of the responsibility of the court to manage cases, and effectively said that defining the issues in the case involves two aspects. The first is identifying what could be debated in a case, and the second is eliminating what would not be debated. It sounds quite simple and straightforward because it is, but he said those two aspects are as important as each other. In that specific case, the argument came from the responding party that the parties would shortly be exchanging expert evidence, and as such, there was no need to respond to the request because answers effectively would be provided in expert evidence. What Mr. Justice Norris said in response to that argument was that there is a distinct distinction between expert evidence, which is to provide opinion evidence on an issue requiring an expert, and a response to a request for further information. Those are two separate issues. In the case of Barnes, the claimants made a Part 18 request of the defendants after issue, but before service of the particulars of claim. And effectively, their argument was that they sought information to enable them to put their case more fully and effectively. But the response came from Mr. Justice Morgan, which said that claimants, what they were doing was asking questions about issues which had not yet arisen between the parties. And that it was in effect not what CPR Part 18 was there for. And he made it crystal clear that what CPR 18 deals with is the position at the time of the application to court. It's only in relation to those matters which are live at that stage that orders can be made. As you would have already gleaned, the relevant parts of the CPR Part 18 and the practice direction of Part 18, that's what we're dealing with today, and that's what I will walk you through in due course. Practice direction 18 provides the bulk of the instruction and information on what's required when making a request, when responding to one, or when you need to effectively make an application following an unsatisfactory response or no response at all. Why do parties make them? Well, the purpose is quite obvious. It helps one party understand the other party's case better, or it at least helps them understand how it is or what case it is that they need to meet. This has knock-on consequences, hopefully positive ones, which aid the early resolution of claims. As I've suggested, there are a number of benefits that parties can get. They can obtain admissions, they can reveal weaknesses in the other party's case, they can obtain information about important facts which the applicant needs to prove in support of its case. You can ascertain details or aspects of the other party's case, so there's less confusion or upset when witness statements are exchanged or at trial. Equally, you can clarify the other side's case, limit their ability to depart from that or substantially depart from that later on in the case. And finally, that point which I've already made, which is simply to narrow issues, reduce expense, heighten chances of early settlement of proceedings. In terms of the specific timing of when to make the application and proceedings, it's been subject to, again, a lot of judicial consideration. The case I've just put on the screen there, the case of Lalana Hands Place Limited and Michael Barclay Partnership. Mr. Justice Coulson, as he then was, nevertheless, but perhaps surprisingly, allowed a request just a week before trial. The responding party made the obvious argument, which was that making or granting an order that they ought to respond to a request that late would disrupt their trial preparations. But it was decided that he wouldn't necessarily refuse it simply on the grounds of delay or how late in the day it had come. His view was that it would form part of the trial preparation and wouldn't actually be that disruptive. And as such, even though it was so close to trial, an order was made that the responding party ought to respond to the request in that case. We've already discussed the case of Barnes. However, the same points made. As I said, in that case, the request came before particulars of claim had been served, and the point was made that this part of the CPR is not designed to allow parties to ask questions about issues which hadn't yet arisen. And equally, conversations about timing comes into it when responding as well. Some parties will respond to a request and say, well, I'm not going to respond to that request because you will get that information later on in proceedings, whenever that might be. And in the case of Fairclough, the judge considered that it was not an answer in itself to say you'll get it at some point or you'll get it later. If the information fell within the scope of the rule and it was reasonably necessary and proportionate to have that information provided at that stage, then the court may order a party to do so, even if it would have been otherwise produced later on in the case. So just taking a step back and looking at those cases, what we can take is that in effect, requests and responses can be made and ordered at almost any stage from issue to trial, provided it's about a live issue in the case at that time and provided the information sought is reasonable and necessary to provide. On the flip side, the question is asked, when should parties avoid making them? What Part 18 requests should not be used as is an opportunity to simply highlight the weaknesses of the other party's case, to flag issues which aren't in dispute, as we've already covered. Phishing requests, of course, where one party doesn't have evidence in support of its statement of case. Requests purely as to the credibility of a witness. It's an obvious point, but that shouldn't necessarily be raised in these sorts of requests. And again, oppressive and disproportionate requests in terms of scope and costs in relation to the value in the case. So looking at the first real part, how do you make a request? Well, Practice Direction 18, paragraphs 1.1 through 1.7 very succinctly and simply take you through when a preliminary request for clarification or further information is made. The obvious point, as we've already set out, is that before you make an application to the court, you should serve this preliminary request on the responding party. It's a written request, and what you should set out therein is a reasonable date for response, obviously taking into account what information you're asking for, the value in the case, or the sums in dispute, as it were. It's an obvious point, but the request should be concise and strictly confined to matters which are reasonably necessary and proportionate to enable the first party to prepare his own case or to understand the case he has to meet. So that is really the main question we're asking ourselves. Effectively, are we confining things strictly to those which are reasonably necessary and proportionate? And there you go, I've just put it up on screen, but that's the emphasis I put in bold. I've put a few cases up on the screen there. Berezovsky, the judge, again, put an emphasis on simply what was necessary to put one's case, but also encouraged the parties to over-provide rather than under-provide, making clear that it's about trying to settle proceedings and not point scoring when making such an application or a request. In the case of King there, Lord Justice Brooke emphasised the word strictly within that provision. And again, the National Grid case there is quite an interesting one, where Mr. Justice Roth found that the supply of the information sought served a very clear purpose and promoted the fair conduct of the hearing or the trial, but in fact didn't grant the request, owing partially to the fact that witness statements hadn't been exchanged, and he did not view it fair to order the responding party to effectively provide fragmented witness evidence early on in proceedings, as opposed to doing it in the usual way. So that's quite an interesting read for anyone so inclined. We are also told in paragraph 1.3 that effectively that practice direction then turns to look at the format of requests. We're told that they must be made as far as possible in a single comprehensive document, not in piecemeal over a number of emails, for example, or in correspondence. It also may be made by letter if the text of the request is very brief or it's very simple, and the reply is likely to be equally simple and brief. Otherwise, what we're told is that the request ought to be made in a separate document. In truth, the difference in practice might well be negligible when it comes to length or form, really, whether in a letter or in a separate request, but it should be a standalone as set out in paragraph 1.4. As we'll come on to see, it has to include a number of things. If a request is made in a letter, the letter should, in order to distinguish itself from any other letters in proceedings, it should state that it contains a request made under Part 18, and it should also not be dealing with any other matters. There's no responding to other issues as you would in other correspondence, or dealing with dates for directions or orders or applications, whatever it might be. It has to be self-contained. Whether in a letter or in a separate document, there are a number of formatting provisions which effectively are all set out in paragraph 1.6. The request must be headed with the name of the court, the title, and the number of the claim. Again, it must state that it's a Part 18 request, identifying the parties and the dates that the request is made. It should be set out in separate numbered paragraph, each request for different pieces of information or clarification, and equally where it's a document you're seeking, you need to identify that document, and if relevant, the paragraph or words to which it relates. And finally, what you really importantly need to set out is the date by which you expect the party to respond. Paragraph 1.6 subsection 2 provides for a very handy and efficient way to set up a request and a response in the same document. It's a sort of schedule whereby you set out the numbered paragraphs of the request on the left-hand side of the screen, or not the screen, I beg your pardon, on the letter or email, and then or request, and then on the left hand and then on the right hand, I beg your pardon, that there's effectively blank spaces for the responses which the responding party can insert their responses in. And again, whether the request is served in that format, there should be a spare copy served for use of the second party to fill in those responses. 1.7 finishes the part of the practice direction on making a request, just effectively by making clear that requests should be served by email, subject to those usual rules in CPR 6.23. So looking at a quick precedent, we can see a very standard precedent for a request. It doesn't have the sort of formal court heading, but all the information that needs to be set out is set out there. We've got the claim number, the name of the court, the title of the claim. It's clearly set out that it's a party request with the parties' names, the date it's made, and the date by which the responding party needs to respond. And overleaf, we can see this request simply made with in numbered paragraphs. It's really simple, it's really straightforward, hopefully done at minimal cost to the client. It can often be very, very helpful based on how low cost it is when you're trying to end proceedings as early as possible. So that's making a request. But of course, we need to look at the other side of the coin, what happens when you need to respond to a request. Practice direction 18, paragraphs 2.1 to 2.4. It's very similar in substance. We know that a response to a request must be in writing, it must be dated, it must be signed by the second party, the responding party, or his legal representative. If the request has been made by letter, it's very simple. You can reply by letter. There's nothing else. Again, it's the same provisions that there should be nothing else contained in the letter. It should be self-contained. It's made clear that the letter is a response to the request. If the response is made in the format I mentioned earlier, with the request down the left-hand side and the space for the responses down the right, it's very simple. You fill in the response section and you return it to the requesting party. If it's made in the standard way in the form of the precedent, which I've just shown you, the same provisions apply, which is that it must be headed with the name of the court, the title, the number of the claim. It must identify itself as a response. And then effectively it has to set out what the request was and what the response is to each request under each paragraph. And if there are any documents, it should refer to them and attach them. And again, if there are any further or supplementary responses, then those need to make themselves clear in the heading as well, although that's rather self-explanatory. If a response is served, it must be served on all parties, filed with the court alongside a copy of the request. So slightly strangely, it's on the responding party to ensure that once it's done, once the response is given, that it is their duty to file that response, but also the request with the court. And it's also worth noting at this stage that any response must be verified by a statement of truth that's set out in 18.1, in part 18.1. So that's something really important. Again, what I would do is put a quick precedent up on the screen. very, very similar. Claim number, court, names of the parties, clarification that it's a response. Overleaf, here you have it. The numbers are slightly wrong, given that they're all numbered 1, but I'm sure you get the idea. You set out the request that was made, you set out the response, and then you move on to request 2, and you set out the response, request 3, set out the response. I'm sure you get the idea. And then overleaf, you have the statement of truth. And in fact, at the top of this, you actually have a polite confirmation as to who it will be served on and that it will be filed at court. So that is that. The next slide perhaps should be entitled not responding to a request, because there are some circumstances where either you're not going to be able to or you won't want to respond to a request, and that's going to be just as important to deal with as responding to a request. There will be, for all the reasons I've already set out, sometimes it will be an awful request, sometimes it will be a phishing exercise, sometimes it will be a scattergun approach. So you will need to effectively not respond. The first job is that you inform the other side promptly and in any event within the time frame provided that you're either unable or you object to complying. So it's rather obvious, but if someone gives you 21 days to respond, it's within that time frame that you ought to tell them that either you're not going to respond or you're not going to be able to respond within the 21 days. And you can inform them of that in a letter or in the formal response that we've set out. But what you should do is give reasons where relevant and a date by which you comply. So if you're going to be able to comply within 28 days, you should say that. Or if you're not going to respond at all, set out why that is. And that's just those provisions being put on the screen there. There's no need to apply to court. You don't need to effectively say, apply to court, say this is why I'm not responding. All you need to do is just respond to the requesting party. That provision there, 4.2.2, is effectively just an example to say that, for example, where a party finds it disproportionate or finds that it will be a disproportionate expense and objects to complying for that reason, then that's exactly what they should set out in their non-response. As we can see here, this is the last stage of where Part 18 applications or requests will get you, which is where if one party has not filed, not served a response, or not served a sufficient one, then the requesting party can apply to court to effectively order the responding party to respond. It's paragraphs 5.1 and 5.8 of the practice direction. Naturally, attention's drawn to Part 23 and Practice Direction 23A. So, of course, any application made to court should be Part 23 compliant. An application notice for an order under Part 18 should set out or have attached to it the text of the order sought as usual. And in particular, what it should also do is specify the matter or matters in respect of which the clarification or information sought. So that's paragraph 5.2, effectively setting out what it is you are asking of the responding party. If an application's made and a request was never sent, you need to set out why not. As I've already set out, the usual course of action is that you make that request before any application. If one has been made, you need to set out in the application notice what it is you've received back, if anything at all. And this, of course, ties in with a wider obligation in paragraph set out in paragraph 5.4, which is for the parties to consider whether evidence and support's required. So if there is correspondence or requests and responses that you want to include in your application notice, you will need to file and serve that evidence alongside the application. Paragraph 5.5 deals with effectively how long you have to wait before you apply to court. And I'll deal with both paragraphs, subparagraphs 1 and 2 together. If 14 days have passed since the request was first served and the deadline for a response has passed, so those 2 points, then and the responding parties made no response, then the first party, what they can do is effectively file that application notice with the court, but they need not serve it on the responding party. And what the court can then do is deal with the application without a hearing. So what this does is highlight the very real danger of not responding at all. even if you are responding to say that you are not going to give a substantial response, or it's disproportionate, or you need more time, whatever it might be, make sure you respond with something, because the risk is that the application notice is filed with the court and not served on you. Otherwise, if those provisions haven't been provided for, then the application notice has to be served on not only the responding party, but all parties to the claim. And again, if the court then decides to make an order under Part 18, then that's got to be served on all of the parties to the claim. In paragraph 5.8, there are cost provisions. Our attention is drawn to parts 44 to 48. An in-depth review on costs on interim applications is for another webinar, I'm sure, so I'll park cost there for now. But if anyone has any questions, please don't hesitate to get in touch on that point. And just finishing up, looking at some practical considerations, I'm sure you would have picked up on a number of these as we've gone along. And a lot of them I doubt I need to tell you, because a lot of them are just some common sense. But when making your application, you need to think about the proportionality of making a request, or indeed an application if it comes to that. This is for obvious reasons. It's going to cost the client money if you are requesting things and making applications. And you need to think about the likelihood of the information you're going to acquire. What will it provide? And effectively just run a cost analysis, a cost-benefit analysis of whether it's going to help you settle or put you strategically in a better position, or whether actually that information isn't going to take you that far. We've seen from some of the cases which we've gone over, cases like Fairclough, that it's about whether your request is reasonably necessary and proportionate to have that information provided at that stage. So think about whether it's absolutely necessary you have the information provided, so that you know the case you have to prove or respond to. So obviously just having that sensible approach to litigation is always the aim. I've just put them up on screen now, but we've covered all of them. When responding, you probably need to be a little bit more tactical than when making a request, because at the end of the day, you're providing a sworn document that in all likelihood will assist the other side in one way or another. Hopefully it will assist you also in trying to settle things early if that's the correct decision. But you do need to think a little more about what information you're providing. Sometimes the question you're being asked is an honest one to help settle, as I said, but sometimes it is a fishing exercise. Unfortunately, you have some litigants or firms that might well take a scattergun approach and send a number of requests early on. So we need to be a little bit sensible about just sort of nodding along and giving that information where it's requested. We've covered the point about settling in a cost-effective way. And sometimes it is best to be transparent if that's what the case requires. The proportionality point we've also dealt with when making, but you need to consider whether it's going to be more costly to object and then be subject to an application which involves instructing counsel and preparing for a hearing. On that point, what I have used an interim hearing dealing with a Part 18 application before is we've been able to settle the entire proceeding. So sometimes in that case, conversely, it was helpful to have an application and have a hearing where the parties were brought together at court. But you do need to think about the costs that an application might bring if there's going to be a hearing. And a final point, which is just, I hope you picked up on it, but it's be robust where required. I've already said some firms and litigants use a scattergun approach, but sometimes you need to effectively not give them that. So be wary of speculative requests is what I would say. That brings us to a conclusion. I hope you have found this session informative. I hope the presentation has assisted you in some way, whether you're a junior practitioner or whether you're someone who's just fresh to these applications or requests under Part 18. I've already mentioned it, but if there are any questions that have arisen in your mind, please do not hesitate to get in touch with me or the clerks in chambers. Again, I hope you enjoyed this presentation and I hope you enjoy the rest of the series. Thanks for your time.